Hearing an appeal, Société de Chasseurs de L'Ile Maurice and the State of Mauritius and another.
Continuez.
Here is my learned friend and Yasser Konai for the appellant, and my learned friend James Guthrie will be appearing for the respondent.
Yes.
Well, my lord, the story of the deer in Mauritius is a very, very long one, but I shall not start with it. I'll spare you this extremely interesting story, which has got nothing to do with our case. Now, the case for the appellants has always been that they had acquired rights from the previous Firearms Act, 1940.
Mm-hmm.
More especially Section 4 of that Act, and that the new Firearms Act 2006 could not have affected those acquired rights in view of Section 17(3)(c) of the Interpretation and General Causes Act. In fact, this section is quoted several times in the cases I'm going to refer to. In short, our Section 17 Section 17, subsection 3, reads like this: subject to subsection 4, the repeal of an enactment shall not, A, B, and then C, affect any right, privilege, obligation, or liability acquired, accrued, or incurred under the repealed enactment. This is borrowed, my lords, from the Interpretation Act, the English Interpretation Act of 1889, where we find approximately the same wording in your Section 38(1).
But that means, doesn't it, on the face of it, that the repeal of the 1940 Act did not affect the right to hold arms under the 1940 Act while the 1940 Act was in force?
Yes.
You have to show that there is something in the 1940 Act which, I would have thought improbably, creates a right which continues after its appeal.
Yes.
And that is almost by definition impossible.
Yes, it's, and we must, in fact, concentrate on Section 4 of the 1940 Act, which gives all the conditions whereby a person can acquire a gun and keep it and, in fact, lose it.
But my point is, it gives those permissions while the 1940 Act is in force.
Yes, exactly.
And so once the 1940 Act is repealed, no one can complain that while it was in force, there wasn't a proper license. But after it's repealed, you have to look for some other source for the license, don't you?
Well, one might, I suppose, treat Section 17 as preserving the validity of the annual licence while it remained, but it couldn't possibly entitle you to a renewal of the licence. And as I understand it, these licences require annual renewal. Is that not right?
Well, the 1940 Act came at its time and failed to be interpreted
But I mean, am I right in thinking that licences issued under the 1940 Act were only annual licences and needed to be renewed? So all of them expired within a few months of the repeal of the Act anyway. Is that not right?
There might be something on that in section 4, subsection 4A on page 401,
Yes.
I think.
Right.
Yes.
Well, in any case, the case for the appellants
Yes.
was that they had acquired, rightly or wrongly, but this is what we are submitted and fought for in the court below. They acquired the rights of having more than 2 guns. I mean,
Yes.
normally 3, 4, 5 at most.
And that's the case you pursue,
Yes.
even after
we
the
are- we
expiry
are-
of the annual licence? Even after the expiry of the annual licence, taking Lord Sumption's point?
Well, we simply suggest that this acquisition under Section 4 of the 1940 Act survives
Yes. But which
after
right are you talking
the
about?
206 Act.
Are you saying that the right which survives is the right under an existing licence, which wouldn't do you much good, or are you saying that the right which survives is the right to have an annual renewal of that licence?
Exactly.
You must say the right
It must be the latter.
This is our case. It's no question of holding guns without a license.
Yes.
But we shall come to this in a few moments, if you will allow me. So what is important is that our Interpretation and General Clauses Act and coming from your Interpretation Act of 1889
Yes.
is couched in mandatory language.
Yes. You say once you've got a licence under the old Act, Section 17.3 entitles you to say despite the new Act, you're entitled to carry on having a licence.
Yes.
Okay, got that, thank you.
And that follows, does it, from Section 44A, which says that a firearm licence is not only annual, but shall, subject to subsection 7, be renewable annually. And subsection 7 has a limited situation where the Commissioner of Police can refuse to renew it. Is that the position?
Well, in fact, what the Section 4 says, it shows that the licenses that are issued under that section are essentially renewable, except if we run into abnormal circumstances.
But the trouble is that Section 17 might save an existing licence, but it can't save a statutory scheme for the issue of further annual licences after it's been repealed.
Well,
Because that's not an existing right.
this is not what the trial judge found,
No, it's not.
and this is what we are fighting for.
You say annual renewability under Section 44A is preserved by Section 17.3.
Yes.
Yeah.
And it is a right, you say, because it says it shall be renewable, as you said, subject to a few exceptions.
Yes.
So in fact, the licence is effectively not an annual one, it's a perpetual one, unless
But it's
unless
not,
the Commissioner of Police brings himself within one of the exceptions.
I wouldn't say it's a perpetual one, because things may occur which would compel a cancellation of the...
Yes, but it does require, on your case, it does require a cancellation. It will go on, it will be renewed.
Or refusal to renew.
Well, that law is made for normal persons. I mean, meaning leading normal lives in Mauritius, not for madmen or whatever.
Yeah.
But if nothing happens, well, as the learned trial judge found, these licenses are not only renewable, but have been renewed for years without any itch of any kind. But of course, The law is there. If anything untoward happens, of course the license will be cancelled, and
Yes, I see.
with the results that are in fact provided by the law itself.
Yes, thank you.
So, I humbly submit that the legislation of 2006 did not intend to oust the appellant's acquired rights.
Yeah.
Firstly, the original intention, as it appears in the bill, was not aimed at creating the restriction of guns to 2. If your lordship look at the new tab 5,
Yes.
you will find that, first of all, the explanatory memorandum doesn't
Sorry,
at all
Tab
mention.
5, I'm sorry, it's the Wildlife Act 1980.
no, of the new bundles.
Of the new
supplementary bundle.
Sorry,
Tab 5.
beg your pardon. Yes, I see. Thank you.
There's nothing in the memorandum itself speaking of a reduction of the number of guns. And then, if we look at Section 4, subsection 2, as it appeared,
I don't, I'm afraid, have a supplementary bundle.
Looks like this.
Well, yes, still don't have it, so share it.
sorry,
Is there spare
I thought
copy
you
of
were
the supplementary?
you had all been provided with
Okay,
this.
carry on. Yep. Where do you want us to look?
Well, in Section 4, subsection 2, no individual shall hold more than 2 firearms of the same type, and then the word similar, which is not very good English, but there you are, shall hold more. No individual shall hold more than 2 firearms of the same type, similar, at any time. That was the original
Yes.
intention.
Yeah.
And then, of course,
Yeah, well, that's the same as the
if
original.
we go to in the same,
No, the original.
The eventual thing is shorter. It takes off the similar type.
Yes, there's an amendment
Yeah.
moved
Yes,
by the
exactly.
Prime
I'm
Minister
coming
at page
to that right away.
1018.
Yeah, but, yeah,
I'm coming
okay.
to that right away.
Okay, but,
If
Okay.
we look at the
yes, but
what took place in Parliament,
what's the point that we're looking at this for? The fact that it's amended so that it doesn't take a similar type anymore, so what?
well, under tab 6, my lord,
Yeah,
where you have the
firearms bill, yes.
the speech of the Prime Minister,
What about the competency certificate?
Sorry?
Do your clients have to have a competency certificate under the new legislation?
yes, we have.
I think they're under the Wildlife Act.
Yes. Anyway, you want to take us to the firearm, what the Prime Minister said in tab 6, is that right?
You ought to have been provided with a
I think you introduced this point by explaining to us that your case is that the original scheme of the new Act was not one which would have affected the chasseur because of the words
well,
similar
it was different at
Yes.
the start.
before the
but
amendment.
As is perfectly allowable, it changed.
Yeah,
Yes.
Of course.
right.
But it changed in a regrettable manner, in the sense that at page, if you look at the new tab 6, where you have the debate in Parliament, you will see at page 995 that the Prime Minister says the number of firearms that an individual can hold would be limited to 2 at any time.
Yes.
That is the warning which is given en passant, in the middle of a series of remarks. And the result is that this question was never debated. Was not debated. There was no mention in the course of the debates of this important change.
Well, no, that's not quite right, is it? the Prime Minister moved an amendment, page 1018.
Yes.
However, what you can say is that the position
Yes,
of the...
course. Well, I'm coming to this now. Yes. At page 1017, the committee stage starts, and then we see the Prime Minister making his amendment, which is agreed to, yes, as a matter of course. What I humbly submit in this connection is that this goes to show that it was not the intention of Parliament to reduce the number of guns of those who already had to. In other words, they never intended the new section 4.2 to extend backwards in order to eradicate the licenses granted under the 1940 Act. Because if that was the intention, well, they would be cheating, in the sense that, in an intellectual view of the matter, they would be getting across the provisions of the Constitution which prevents a nationalization of that sort to happen without any compensation whatsoever.
Well, that's a different point.
Well,
That's your second point.
Yes.
Well, I submit that
It's a circular argument.
this was not the intention.
Yes. Why? How do you get that intention? Where do you get the intention of Parliament from? From the original draft, you say?
Well, the section such as it now exists, and that is section 4.2, must be looked at for the future. It's prospective in its application, in my humble submission. It doesn't go back to licenses which had already been granted.
But the bill was initially presented, I think we see on page 1020, that clauses 47 to 52 were ordered to stand part. And if we look at clause 51, which I don't think is in the bundle, but is in the
Yes.
in the judgment of the judge at first instance,
Well,
at page MS 108,
Yes.
the transitional provision is that any
Indeed,
license
yes.
or permit issued under the Repealed Firearms Act, which hasn't expired, remains valid until the date of expiry. So it might be said against you that the Act, as initially presented, did envisage such licenses as existed under the 1940 Act expiring at their due date.
Well, there's no doubt that section 51 provides that the carrying of 3 or more guns would remain lawful until the end of the year, when their respective licenses would lapse. Mm-hmm. So the chasseurs could have gone parading in Port Louis with 4 or 5 guns in front of the Parliament, but they didn't do it. And in fact, the Commissioner of Police wrote to them. This is where perhaps we could refer to this document, which appears in the main bundle. Do you have any copy?
maybe page 100. Then on your maybe page 140. Page 140. Are you looking for page 140 of the...
Is it the police communique you're looking for? MS 140.
This was illegible in the publication, and in fact, neat copies were provided.
Yes, I think we've just got it, haven't we?
Yes.
Right, now, this is action taken by the police. They are drawing attention at Section 2 of this police communique, Section 4.2 of the Firearms Act 2006, which provides that an individual shall not hold more than 2 firearms at a time. Individuals holding more than 2 firearms are requested to contact the firearms officer of the District of Renewal for keeping of any firearm in excess of the 2 firearms allowed by law in the safekeeping service provided by the Commissioner of Police. Now, I humbly submit that this, first of all, there is absolutely no backing in the law itself for this initiative by the Commissioner of Police. And it goes to show the absence of any directions in that respect, goes to show that the Parliament never thought of going back to the 1940 licenses and cancelling them. This is a sort of impromptu initiative taken by the Commissioner of Police. And I humbly submit that, of course...
Which aspect of this do you say is unauthorised? The requirement to deposit the firearms in the safekeeping of the Commissioner?
Yes.
Is there no basis for that in the Act?
Well,
in the new Act?
It's not in the Act. In fact, the trial judge, in his judgment, found that the Commissioner of Police has been using a section of the law which has got nothing to do with the action he has taken. If I may draw your Lordship's attention to the judgment on this point.
I mean, Section 15A appears to prohibit the possession and use of firearms according to the title, but we don't have that copied in the authorities bundle.
Well, the trial judge, my lord, dealt with this in the main brief at page 106.
Section 22. I'm sorry, paragraph 39 of the judge.
Exactly.
Yes, got it.
Exactly. Had Parliament envisaged that the extra firearms were therefore to be taken over by the state, the surrender section would have effectively provided for such surrender. As it is, all that Section 22 of the Firearms Act 2006 does is to provide for the surrender of those firearms whose owners are to be absent from Mauritius. And it quotes Section 22, which is in fact borrowed from the 1940 Act. They have exactly the same as the 1940 Act. If a Mauritian wants to travel he shouldn't leave his guns at the mercy of anyone at his place, and the Commissioner of Police is entitled to see to it that it is kept under control.
So the point is it that what Section 22 does is provides for the Commissioner to render a voluntary service which licence holders can take advantage of if they wish.
Yes.
And the point the judge was making was that it doesn't make it compulsory. Is that it?
Well, it isn't compulsory, no.
Yeah.
But
Should we not be looking at you've referred to Section 22, which I don't think has been copied.
All Section 22 says is
I think it's in the new bundle, my lord.
the Commissioner shall provide a safekeeping service for firearms and ammunition belonging to private parties.
It's also in the judge's judgment at paragraph 39.
And also Section 15A, which appears to prohibit the possession and use of firearms, presumably without a licence. I'm simply looking at the index of the statute, most of which we don't have.
Section 15A says no security guard on duty at the premises of a nightclub, discotheque, private club, restaurant, cafe, pub or bar.
Well,
that
this
can't
is,
be it.
No.
Well, this is something specially provided for those who this is for those who help to keep the peace. We have a number of providers of private policemen, and this is in respect of those people that this Section 15(1) has been enacted. Now, the learned trial judge continues at page...
Well, it's perhaps Section 3 that we should be looking at, because it says that no person shall have in his possession any prohibited firearm. And a prohibited firearm is presumably an unlicensed one.
Not necessarily. No, prohibited firearm is a particular variety specified in Schedule 1,
I see.
interpretation section 2,
I see.
Well,
as it is in this country.
okay. Now, shall we just complete what the judge said? In the circumstances,
That sort of thing, yes.
in the circumstances, the recall of the extra firearms and their, so to say, safekeeping made worse by a rental of 100 rupees amounted to a deprivation of the properties of the plaintiffs under Section 8(1) of the Constitution, because there is absolutely no authority whatsoever for this taking over.
But for the taking over, is this police communique actually necessarily suggesting a compulsory taking over? It leaves it open to an individual to solve the problem of holding more than 2 firearms by selling one or giving it to his wife. It doesn't say you must do this.
The police can't be blamed for what they did. I mean, to say, they were faced with something new and unexpected. and they said to themselves, well, these chaps under Section 4(2) are going to be in unlawful possession of a number of guns. So we must do something about it. Yeah. And this is what brought this initiative by the Commissioner of Police.
Yes, but if the police hadn't done that, then the options of the firearms holders would be either to sell the gun or to transfer it into the ownership or possession of someone.
The gun.
Or someone else.
Like
so let me finish the point.
Sorry.
Why can't you sell the gun?
Someone else with a license. There's 2 options. One is you sell it, or you transfer it into the ownership and possession of someone who has a license and no more than 2 guns. Yes.
That is what the police suggested, according to the evidence.
How many guns does a proper chasseur need to pursue the game in Mauritius?
I should say 3 or 4.
Well, the entirely different types
in the
of guns.
sense that you have the strong rifle for deer, and then a shotgun for hares, and then there's always a third one for minor game like wild boars. And I should say that with these 3 guns, you are fully equipped. But some go on to have a .22, which can be helpful in achieving, killing an animal which is just injured.
Which
I
is
mean,
just can help kill an animal which is just
Injured, I think.
oh injured.
Injured, yes.
Yes. I mean, a .22 can be used for hares as well.
Well, it can be used for
yes.
hares, but sitting hares, yes.
Yes, not running ones.
But this is,
But all that was dealt with in evidence before the judge, wasn't it?
yes,
That's exactly what the evidence was.
that was,
Different game, different weapons, obviously.
yes.
Yeah.
So the police, having done that, as the judge found, the chasseurs obeyed under protest and went to court.
Can I just ask about this? You took us to helpfully to the debate.
Yes.
Just before you leave it, could you go back to it? It's in the supplemental bundle at tab 6.
Good.
And I just wonder whether there's anything you want to say about page 1011. There's no need unless you want to, but there is a reference to the Société de Chasseurs there, isn't there? In the debate.
Yes, which line, my lord? If you
Halfway down, exactly.
Oh, yes. Yes. I have had representation from la Société de Chasseurs, 500 signatures, relating to fees.
And then?
They are very happy with the bill, but they were worried because of the sudden step increase. Yes, but the bill, as I said, and as I pointed out, the bill didn't, to start with, cut down the number of guns.
Well, it did, but it only cut down the number of similar guns. So your point is that this was before the amendment.
Correct.
Yes.
That's before the committee
Exactly.
stage.
Yes, sir.
Okay, that's what I thought. Thank you very much.
Now, as I humbly submitted, or have I not yet done it, I submit that it would be unfair towards Parliament to suggest that they intended to cancel rights acquired under the previous law, irrespective of the consequences under Article 3 and 8 of the Constitution. I mean, with their open eyes, they would run into the Constitution. This is unbelievable. I mean, there's something that shows, there's something there that shows that their intention was aimed at the future. In future, you will not be able to have more than 2 guns, but those who already have licensed possession of 3 or 4 guns, well, they're not concerned with them. May I, at this stage, refer your lordships to 1 or 2 cases, recent cases, which buttress the trial judge's findings. The first is Shanto, which has already been mentioned in the judgment, but which needs to be looked at carefully. This is in tab 26 of the it was a case, tab 26 of the of the bundle. This was a case a criminal case under the Customs Act. And if you look at page 769, their lordships quote the new provisions which are under an Act of 1998, and section 1482 reads, proceedings for any offence under section 156 or 158 may be instituted at any time. May be instituted at any time. The open sesame to what the other side thinks it is, the law is retrospective. It's any time backwards or forwards. This is their interpretation. This is going to be the interpretation of the Court of Appeal in Mauritius. Crystal clear. It's not crystal clear at all, because as you see, my lords, the judges in the case of Shanto bypassed this formula without any hesitation. At page 770, we believe that the answer is to be found in section 17(3)(b) and C of the Interpretation and General Clauses Act, which provide that, as I've read earlier. And our reading of section 17 of the IGCA is that the provisions of Act 10 of 1998 can have effect only for the future and cannot affect the 3 years limitation existing prior to the amendment.
So what the court was saying was that there was an accrued right to a 3-year limitation period by the time the new act was enacted.
Yes.
The case against you is that you had an accrued right to an annual license, but no more.
Yes.
And when that license expired, Section 51 had the effect that you were brought, there was nothing retrospective, but you were brought into the new world of the 2006 Act. That I think, is the government's case.
Well, there is perhaps a fine distinction to be made, but I will.
I wonder whether Shanto is actually correct as a matter of law. I mean, a limitation defence is essentially a procedural defence. Normally, matters of procedure can be changed with effect, immediate effect, including on existing subject matter. But anyway, you say it's correct.
Yes. What is interesting also, at the end of this Shanto case, the lordships commended the stand of learned counsel for the respondent who did not support the appeal.
Is the authority for the police certificate, is that not section 44 of the Act at MS 956?
Section 44 of the Act.
Yeah.
Of the
that is
2006 Act, you mean?
Yes, that doesn't. Your submission is that doesn't apply to unlicensed firearms, but only to firearms that have been left in Mauritius while the owner goes elsewhere. Yes, I follow. Okay, sorry. False trail. Forgive me.
Abroad.
Yes.
Yes. This is, in fact, Your Lordship, this section 44 is borrowed from part of section 4 of the 1940 Act.
It's a bad point I made to you. I remember you were making this submission.
Yes. So this is the unforeseen circumstances that crop up and necessitate the surrender of the gun.
Yeah.
Now, we have two English cases that should be quoted to Your Lordship, Your Lordships. One is the Secretary of State for Energy and Climate Change and Friends of the Earth and others. This is a 2012 case. It is in tab 28 of the bundle. It's the Court of Appeal Civil Division judgment. And Your Lordships, at page 793, paragraph 44, and 794, paragraph 45 and 46, there's an important statement of the law in my humble submission. In Wilson against First County Trust Limited, 2004, Lord Nichols adopted the principle expressed by Lord Justice Stoughton in Secretary of State for Social Security against Tunnicliffe in 1991. The true principle is that Parliament is presumed not to have intended to alter the law applicable to past events and transactions in a manner which is unfair to those concerned in them, unless a contrary intention appears. It is not simply a question of classifying an enactment as retrospective or not retrospective. Rather, it may well be a matter of degree. The greater the unfairness, the more it is to be expected that Parliament will make it clear if that is intended.
I don't understand why there's any doubt. We're faced with a transitional provision, section 51(1), which on the face of it seems very clear, doesn't it? The intention is that existing licenses are protected until their expiry, and after that, by clear inference, you have to apply under the new Act. So why are we worried about cases of interpretation in cases of doubt or about the Interpretation Act?
Well,
I mean, what's unclear about Section 51?
what is unclear in?
What is unclear in Section 51, subsection 1 of the 2006 Act?
Ah, yes, I see. Give me a second.
Because you're referring us to authorities
Yes.
About the position when there's lack of clarity, or about the interpretation, and to the Interpretation Act, but it doesn't seem to me that there is any lack of clarity.
Well, what is the subsection which is attracting your attention?
Subsection 1 of
Subsection
Section
1.
51 on
Yes.
MS 960.
Yes, well, any license or permit issued under the repealed Firearms Act, which has not expired on the coming into operation of this Act, shall remain valid until the date of its expiry.
Yes.
So they are sparing the 1940 Act licenses for a further 3 months.
Yes.
But that quite clearly
Well,
not
this
that
goes
necessarily means, doesn't it, that once the existing licenses have expired, the only right that you have to possess a gun is the one conferred by the new Act, because once the licenses have expired and the Firearms Act
Yes.
of 1940 has gone,
I agree, but how? Section 51 gives the minister powers which he has not exercised at subsection 3. Where this Act does not make provision for the necessary transition from the repealed Act to this Act, the minister may make necessary regulations for such transition. I do not see how he would be able to make regulations under the Constitution. But in any case, he could have made some sort of regulation
Yes, so your
to
complaint...
deal with the extra guns. He didn't.
Yes, well, so your complaint, I mean, Section 51, subsection 1 is clear enough, and your complaint is that a constitutional one, that we should have, either Section 51, subsection 1 is contrary to the Constitution, or else under subsection 3, the minister might have made further regulations which brought the matter into conformity with the Constitution. Well,
it goes to show, to start with, that the prohibition of Section 4.2, of the new Section 4.2, as amended, or the amended Section 4.2, is not as absolute as one would think.
Well, oughtn't we to look, if your real complaint,
it
the
would
real
allow-
nub is the constitutional complaint, oughtn't we to look at the constitutional complaint at some point?
Well, as far as the Constitution is concerned, there's nothing which takes into account the right of the gun owner to be compensated, and of course to enjoy the various
compensation be?
other safeguards that are to be found in Section 8.1. of the Constitution.
But there are two questions out there on Section 8.1. One is whether the new Act whether the new Act involves taking possession
Yes?
of the unlicensed gun. It doesn't, does it? It simply requires you've explained to us that the police system of custody was purely voluntary, not warranted by the Act. So that the Act doesn't involve taking possession compulsorily of anyone's guns. It simply requires them to get rid of them unless they lend them to the police.
Well, yes, all this is, all these actions taken by the police were of their own initiative. I mean, they had no guidance in the law to deal with such an unusual situation.
But they weren't compulsory arrangements, as you've explained to us. So the custody arrangements by the Commissioner of Police can't infringe 8.1, can they? But all that the law does on that footing is it simply requires you to get rid of an unlicensed gun. It doesn't compulsorily, the state isn't compulsorily taking possession of it. There's simply a voluntary facility under which, if you've got no other way that you want to get rid of your gun, you can leave it in the custody of the Commissioner of Police.
Yes, well, yes. I mean, this has to be, it's an interpretation of this text by the Commissioner of Police.
What do you say about the Act is contrary to Article 8.1 of the Constitution?
Well, what I do say is that Section 8.1 of the Constitution prevents any such taking of possession at all.
But where is the taking of possession?
Well, the fact is that everybody, they are all law-abiding, and they have all complied with the police.
Yes, but tell us what is the taking of possession that you say happens under the 2006 Act?
Well, the critical word is compulsory taking of possession. Yes. I mean, if the owner of the gun has the option of selling it or of giving it to a trusted relative who in turn can get a license, then there is no compulsion in giving it to the police. You only give it into possession of the police if you don't exercise one of those other two rights which the legislation leaves open to you.
Or you could destroy it.
Well, the normal thing would have been, if they intended really seriously to stop the extra possession of extra guns, they should have gone straight to Section 8 of the Constitution, should have named a compensation or fixed a compensation, named an accession to the Supreme Court where the owner of the gun could discuss the amount of compensation or even the taking of possession itself. All this is provided in Section 8.
What would the compensation be? The Act doesn't stop you from selling the gun.
Well, the compensation would be a sum in rupees. I mean, a gun.
But why? The gun is worthless because you can't use it and you can't keep it.
Yes.
So, but you can sell it. So you haven't suffered any loss.
You can sell it, but this is, of course, a pis-aller. I mean, they have the trouble of selling it, and in the meantime paying 100 rupees to the police for safekeeping, etc.
Are there licensed firearms dealers in Mauritius? I expect there are.
Well, I think there must be, because there's a specific exception.
Well, there is, exactly. Are there licensed firearms dealers in Mauritius? Must be, mustn't there?
Yeah.
Right. Well, is there anything to prevent a chasseur who has 3 guns selling his third one to a dealer?
Yes, he could find some way of recouping his loss of one gun, certainly. But this is not, I humbly submit, the way to do it. It is a nationalization. Well, suppose, my lord, as there is too much traffic in Mauritius at the moment, and the police comes out with the law saying you have 3 vehicles, well, that's one too many, and leave the third vehicle in the line barracks, pay me 1,000 rupees for its upkeep until it is sold, and
That's not what this
that's
law
that.
says.
Well,
It's not
I
what
mean,
this law says, is
this is completely against the spirit of Section 8(1) of the Constitution, which says that if you want to take possession for good reason, there are certain steps to be taken in favor of the owner. So I was quoting from the Lord Moses, and you will see, well, your lordships will read it for yourself. Section 45 and 46 deal with this problem.
Of what? Oh, section 45 and 6 of what?
Of Friends of the Earth.
Oh, I see,
It's
Friends.
46 that helps you most, isn't it?
Yes.
An admittedly weaker assumption, but nevertheless an assumption against an alteration of vested rights unless the contrary is made clear.
Yes,
Yeah.
indeed, yes. The last paragraph 46 is eloquent. Now, the other. Vous avez une copie de moyen légalement. Non, la prochaine affaire. The other case I had to quote, your lordship, is the case of Manchester Ship Canal Co. Limited, of which you must be aware, against United Utilities Water PLC. It's a 2014 case.
Yep.
Could I have it?
We haven't got it in the bundle, but it's a recent Supreme Court case.
Thank you.
Very much.
Oh, I think this would be good.
Sorry. C'est un familiar.
Quelle section? Your lordship, in this case,
Three of us are familiar with the case.
deals with the Interpretation Act 1978
Yep.
in at the page 2593 of the weekly law reports, and you have paragraph J and H at the bottom of that page.
Yep.
The Interpretation Act 1978.
Yep.
The 1978 Act lays down general rules applicable to the interpretation of statutes. Section 16(1)(c) of that Act provides that where an Act repeals an enactment, the repeal does not, unless the contrary intention appears, affect any right, privilege, obligation, or liability acquired, accrued, or incurred under that enactment. The traditional view is that Section 16(1)(c), like its statutory predecessors, applies only to existing or vested rights. However, the precise nature of a vested right is somewhat elusive. The problem is very close to that thrown up by the presumption against retrospective legislation, which was illuminatingly discussed by Lord Roger of Earls Ferry in Wilson against First County Trust Limited, 2004, appeal cases. At paragraph 196, Lord Roger said this of the cases on vested rights. It is not easy to reconcile all the decisions. This lends weight to the criticism that the reasoning in them is essentially circular. The courts have tended to attach the somewhat woolly label vested to those rights, which they conclude should be protected from the effect of the new legislation. If that is intended so, then it is perhaps only to be expected since, as Lord Mustill observed in l'Office chérifien des Phosphates against Yamashita Shinebon Steamship Company, 1994, the basis of any presumption in this area of the law is no more than simple fairness, which ought to be the basis of every general rule. At paragraph 201, Lord Roger suggested that the test could well be expressed thus. Would the consequences of applying the statutory provision retroactively, or so as to affect vested rights or pending proceedings, be so unfair that Parliament could not have intended it to be applied in these ways? In answering that question, a court would rightly have regard to the way the courts have applied the criterion of fairness when embodied in the various presumptions. And now I may turn to the Court of Civil Appeal, Lord, at page 220 of the main brief. There are certain mistakes in this judgment which I must underline. At page, the judgment of the Court of Civil Appeal start at page 214 of the main brief.
Yeah.
And we start with sweeping statements in the first paragraph. In the fourth line from the end, it is speaking of the license itself was valid until 31st December and was renewable annually. Moreover, it could be cancelled at any time or its renewal refused. This is a very sweeping statement. This is not so at all. Under Section 4, there had to be certain serious events so as to allow the Commissioner of Police to interfere. And then after listing the various stages of the trial judge's judgment, we reach a very surprising paragraph at the bottom of page 223. It says, "It is not disputed that there is no right to a license and that the respondents had no right to a firearms license, be it under the Firearms Act 1940 or under the Firearms Act 2006. It is equally not disputed that such license can be revoked at any time. It is accordingly wrong to hold that Section 17(3)(c) of the IGCA could find its application here." Well, I humbly submit, first of all, that we'd never agreed to anything. And it is unfair for the learned judge to say that it is not disputed, and as if, he says it twice, as if the defendants in the court below had a free hand to make those averments. We fought against all these averments throughout the case, and we never agreed to anything.
It's a question of law anyway. Either you do or do not have those rights. It's ultimately a question of law, so no concession by you would be binding on this court. But you say it's quite wrong to say that a licence can be revoked at any time. It has to be revoked on cause. There has to be what you call an untoward event.
That is the conclusion the learned judge. That is the conclusion the learned judge reaches.
Yes, and you say this is wrong.
But before that, he starts with, it is not disputed
Yes.
that there is no right, and then further on, it is equally not disputed that such license can be revoked at any time. All these are sweeping statements concerning admissions or anyway, failure to dispute of our side. And it's unjust. I mean, we've never adopted that attitude. And my Lord, it is clear that we were on a different wavelength. Now, when we know for a fact that the licenses under under the 1940 Act had been, first of all, under Section 4, are essentially renewable, because in the absence of any objections or special event, the Commissioner of Police had no option but to renew under Section 4. If there was none of the obstacles that could have been raised in the meantime,
we've got that.
The Commissioner of Police shall renew.
Yeah, we have that.
Yeah.
Therefore, that's why I say those licenses were essentially renewable
Yes.
in their nature.
Yes.
Now, of course, this is completely contrary to what the learned judge is saying at the bottom of page 223.
Understand.
But, Lord, is what the trial judge found is to be found page 89.
Yes.
Of the page 89 of the main brief.
Yeah, well, we have to decide what the law is. Yep. I don't think it's page 89. I see now, I see.
And then at page, my own submissions are at page,
Well, yes,
sorry, I mistook the number for,
in the end, we're concerned with not with the submissions or what the court said.
89.
In the end, we're not concerned with precisely what the court said or what your submissions were. We're concerned with what the law is.
Well, my submissions are at page 89, start.
Yes, we see
the
that.
whole of page 90.
Yes, we see.
And the top of page 91.
Yep.
So, as a result, the trial judge admitted some of those submissions and delivered judgment accordingly.
Yep.
So therefore, my lords, I humbly submit that the the trial judge's judgment should be restored and applied exactly as it says.
Yes.
It is worth, my Lord, it is worth noting that in section 2, in fact, we quote it too rarely, but this is the key to the whole Constitution. Section 2 says this Constitution is the supreme law of Mauritius. And if any other law is inconsistent with this Constitution, that other law shall, to the extent of the inconsistency, be void. Now, if you will please bear with me for a few seconds, I read to you the beginning of section 8 of the Constitution. No property of any description shall be compulsorily taken possession of, and no interest in or right of a property of any description shall be compulsorily acquired, except where, and then we have the conditions, which are not present, by the way, such as a breach of the peace or interest of defense, public safety, etc. There's absolutely no evidence as to that. And then we have further, a provision is made by law applicable to that taking of possession or acquisition for the payment of adequate compensation and securing to any person having an interest in or right over the property a right of access to the Supreme Court, where, of course, we would discuss not only the amount but the propriety of. I've done, my lords.
Very well. Thank you very much. Mr. Dunne.
Well, I do not intend to follow. I shall be reply to the advice.
Thank you very much indeed. Thank you, Mr. Dunne. We will rise to consider where we've got to, and we will return in a few minutes. The court is now adjourned. The board is very grateful to Monsieur Dunainville and his junior counsel and instructing solicitors for their written and oral case. We've considered the arguments, and while, as I say, we have been impressed with them, we do not need to call on Mr. Guthrie with the benefit of his written case and the judgment below. We think we have sufficient argument to dispose or to advise to dispose of this appeal. So while we're most grateful to you for your arguments, I think the board will now take time to consider their judgment. Thank you very much indeed.
My Lords, may I just mention one matter?
Yes.
The Court of Appeal awarded us our costs at first instance and in the appeal. I ask for our costs of this appeal if we succeed.
Mr. Dunainville, do you oppose that, or would you prefer to wait to see the judgment? If you would rather wait to see the judgment, I'm not suggesting there'll necessarily be anything in it that helps you.
Anyway.
Yes,
You prefer to wait for the judgment?
yes. We'll
Okay.
wait for the judgment.
That is fair enough. Okay, Mr. Guthrie, you're quite right to raise it, but we will we will either make a provisional indication in our judgment as to what we think, and if it's what you ask for, then Mr. Dunainville can make submissions to the contrary, or we will leave it open, in which case you can apply for your costs.
Right.
Thank you very much indeed. Thank you all very much indeed. Court's now adjourned.